How are juries selected? There are three basic steps involved in jury selection. In Stage 1, the courthouse administrators compile a master list of eligible citizens using voter registration lists, public records, telephone directories, and other sources. These citizens usually live in the local community. In Stage 2, they randomly draw and summon jurors to attend the pretrial process. The goal is to obtain a representative sample of potential jurors, although the process is imperfect. In Stage 3, the attorneys attempt to build an unbiased jury. They do this through the voir dire process. Essentially, they ask the potential jurors questions and try to infer who holds what attitudes. If a juror's beliefs are in conflict with their arguments, they may choose to exclude them. Prospective jurors can also be excluded if they know one of the involved parties, the defense or the prosecution, if they have an interest in the outcome of the case, or if they have already formed an opinion about the case. In fact, the trial can be postponed or moved to another location if the entire pool of citizens is proven to be biased through this process. However, the number of exclusions is limited, so both parties must choose carefully. In some situations, attorneys can use what are called peremptory challenges and exclude jurors without the judge's approval. Throughout this third stage, lawyers rely on their implicit personality theories and stereotypes to make judgments about which jurors may be more sympathetic to their argument. A person's implicit personality theory is their set of assumptions about how attributes are related to each other and to behavior. When they are interviewing a woman, for example, they might assume that she will be more skeptical about the evidence than men, which could lead them to exclude her. Whether these theories are accurate is a different story. These theories are based on stereotypes, which you learned about in a previous lecture. The problem here is that lawyers rarely acknowledge that stereotypes play a major role in their decisions in the courtroom. Interestingly, though, the social psychology research does not support the myth that jurors' demographics predict their verdicts. In other words, we can't predict how they'll vote simply by knowing their demographics. Some attorneys use what is called scientific jury selection. This method uses statistics to determine the relationship between demographic variables and trial-relevant attitudes. Because lawyers are often not allowed to ask jurors intrusive and personal questions, they try to determine jurors' attitudes and verdict tendencies from information that is known about them. The relevance of this information can be determined through focus groups, mock juries, or community-wide surveys. Then, during voir dire, lawyers ask prospective jurors about their demographics and use peremptory challenges to exclude those whose profiles are associated with unfavorable attitudes. Does scientific jury selection work? The jury is still out, and more research needed. Is scientific jury selection ethical? Its proponents suggest that it's a more refined version of what lawyers are already allowed to do. Its opponents, on the other hand, argue that it tips the scales of justice in favor of wealthy clients who can afford the service, an outcome that further widens the socioeconomic gap within the courts. Take a moment to watch this video about scientific jury selection posted on Blackboard. The news report covers a popular television show, The Bull, and its depiction of this modern technology. In the next part of the lecture, you'll learn about some of the factors that influence jurors' decision-making and some of the strategies that are known to produce less biased juries.